But as you say, that the second point the Court of Appeal point out is that the utility, what we call the utility of cross-examination. The defence may well say to the complainant in cross-examination, well, you're not handing your mobile phone over, are you? Because there are messages on there that would show that you're lying about this allegation, weren't you? I mean, it's a very dangerous thing to be saying to a complainant, isn't it, that you're lying, particularly without any evidential foundation.
And of course, at the other end of the spectrum, there's the person who engages in wholesale deletion of stuff from their phone, as from the point at which the officer says, would you mind awfully letting us have a look at your mobile phone? That is the opposite end of the spectrum. That, I would have thought, might well form the basis of some sort of abusive process argument. Look, something's not right here because of the wholesale deletion of messages.
Well, quite. And even if we don't get to that stage, I think the jury would find something like that deeply suspicious, wouldn't they? The police officer asks at 9 o'clock on Monday morning, can you come in this afternoon and give me a mobile phone? And at 10 o'clock that morning, the complainant starts deleting all her chat history on all her messenger apps. And that's not to say they might not have very good reason for doing that, and they might have a very good explanation. They might say, for example, I've got a medical condition I've been discussing with friends and I didn't want anyone else to know about it, or whatever it is. They may have something that they're perfectly entitled to keep private. It will always be a matter for the jury, won't it, in cases like that, whether or not they think they had a legitimate reason for deleting these messages or whether it was done for some ulterior purpose.